Hello, Mr. Willick. Why don't you introduce yourself and let us know your areas of practice and some of what your firm does?
My name is Marshall Willick. I am the principal of the Willick Law Group, a domestic relations and family law firm in Las Vegas. I've been doing this for about 40 years.
With this perspectives video, we're hoping to get some insight on the recent Supreme Court publication, Kilgore v. Kilgore, which implicates pensions. But first, would you let us know the extent at which your firm is involved in the division of P.E.R.S benefits?
Sure, both generally and in this case, I've been teaching lawyers retirement benefit division law for probably 30 years, published a couple of books and lots of articles. I've taught a lot of courses on that subject. The firm has a division called Q.D.R.O Masters, which actually drafts retirement benefit division orders, private ones under ERISA, public ones for public employees under P.E.R.S, military, civil service. We do all of them through our Q.D.R.O Masters division, and we actually drafted the Q.D.R.O that was discussed in the Kilgore opinion.
To what extent would you say the recent publication alters the approach a court can or may take in ordering P.E.R.S benefits divided or distributed to the non-employed spouse?
Kilgore didn't really breach any new ground. It's pretty much standard under the established case law. Gemma, Fondi, Cerdic, Wolf. What a court can do and how it can do it was pretty well laid out. I probably should admit I had some involvement at the trial level as well. I was the expert witness for the wife on how P.E.R.S benefits work when this was at the trial level. But the opinion itself didn't change any of that. It simply recognized the existing case law and allowed it to be applied to the facts and circumstances of the case. The husband in this case, the P.E.R.S employee under police fire, was asserting, and we see this every now and again as an assertion, that no benefits could be divided until he actually retired, which he called full maturity. It's not really an appropriate use of the terminology, and his contention was rejected as it should have been. Just to keep our terms straight, they mixed up vested and matured and accrued, and let's just make sure that we're clear. A pension is vested when it can't be taken away. In this case, before this case began, as soon as he had 5 years of service in, he was vested in the system and therefore had benefits that couldn't be lost. Matured is when something is eligible for payment. Sometimes people talk about full maturity as being eligible for payment without an early retirement penalty. And he was there too. He just hadn't reached the maximum possible retirement benefits, which they addressed with the word full maturity. And that's not really what those words mean, but used in context, it's not a problem to interpret it. Basically what they said is, even if you're not at 100% of your maximum accrued benefit, if you're eligible for payments without reduction for early retirement, you are matured enough for division with a former spouse under the Luciano, Gilmore, Henson doctrine. So yeah, it's again an application, not anything truly new and novel.
Do you have any insight into the panel's word of caution with regards to a judge's exercise of discretion in ordering the amount of periodic payments? Because it appears that this sort of creates, I guess what you could say, at least a temporary out for somebody who is refusing to retire, but at the same time isn't necessarily ordered to pay the full amount that they would be paying because of that specific provision in the publication.
I'm not sure it was a caution. I think they really congratulated the judge in looking at the total amount of financial circumstances of the parties and fashioning a payment on arrears. You'll notice the citation to the Reed case, which is quite old, I mean multiple decades. And basically what it says is a court can fashion a payment on arrears in a reasonable way. Well, there were two to the Kilgore decision that were new and interesting and resolved an unknown in Nevada law. There's a split nationally on the use of accrued sick and vacation time. If you go to my CLE materials, you find two very long lists of cases of about equal length from around the country, with some courts saying yes and some courts saying no as to whether or not accrued but unused sick and vacation time is marital property. And Nevada just came out in this decision as siding with the group that says yes, it is. And that's an appropriate ruling. It matches community property theory well and is a good advance to the law. So that's something that all practitioners should take note of, because that can be quite valuable. The other thing that was interesting about Kilgore and was noted and appreciated was the recognition by the Nevada Supreme Court of NRS 125.150 sub 3. And what that is our partition of omitted assets law, which was specifically enacted, as the court noted, to overrule a holding by the Nevada Supreme Court in a case called Doan versus Wilkerson. And it allows a party to a case for 3 years from the time they discover that by fraud or mistake an asset has been omitted from a decree of divorce, to get back into court and divide that presumptively equally between the two parties, like any other piece of community property. And this was, it's a very long story as to why this statute exists, and probably longer than you want to have in this discussion, but it's been 26 years in the making for that statute and that statutory fix to go into effect. But it is finally there, and they recognized its application in this case.
Before we sign off, I wanted to give you an opportunity to talk a little bit about MLaw, which is a little piece of software that's of great interest to us at our Nevada judges. You can go ahead and elaborate on that.
Sure. Well, MLaw is actually a suite of programs. It's kind of funny. You're in my this interview is being taken in my conference room, and sitting on the wall is the original version of the MLaw software, which was actually on floppy disk back in the day. MLaw 1 was a calculator for calculating child support and other judgment arrears and interest, and then penalties when the penalty statute arose on those arrears for child support, because the calculations became very, very difficult. The legislature changed the statute to change the interest rate that applied every 6 months, and it became very difficult for people to do this manually. So the original MLaw program was a arrearage calculator, and that still exists as it's been amended and as the law has been amended over the years. It's now a subscription-based service that lives on the internet. MLaw 2 was the case summaries program, and that's probably the one you were dealing with. People have often called looking for information, and what MLaw case summaries is basically a playing field leveler. It gives everybody access to essentially all the relevant family law information there is. First, of course, all the published cases and all the summaries of all the published cases, and the briefs that led to the major cases, and every law review article, CLE article, or other important published piece of information, all the rules and statutes, of course, that relate to the practice of family law in the state of Nevada. And it's all searchable by word. So if you really wanted to know what the parties to one of the lead cases had to say and the arguments that they used in arguing it, you can search all the briefs for all of the major cases that are in the Nevada family law field. And the idea is that it's usable by anybody anywhere. You can pull it up on your phone, you can pull it up on your computer, it all can be cut and pasted. So if you're standing in a courtroom and somebody starts talking about Smith versus Jones and you think it's hogwash, you can pull up the case and check it right there and then and hopefully correct it. And not only the lawyers have it, but some laymen have it, and all the courts have it, both appellate and trial level. So it hopefully makes stuff a little bit harder to get away with, which was part of the function. and it's very user-friendly and very easy. It's an easy place to begin your research. If you can think of any family law topic, you can pretty much find anything that's been written in Nevada that relates to it. And there's a lot of national cases to the degree that they're relevant to the Nevada case law as well, United States Supreme Court, Ninth Circuit, whatever. MLaw 3 will be coming out fairly shortly. Actually, MLaw 3 already came out, I'm sorry. That's the Malmquistizer. There's a case called Malmquist versus Malmquist that calls for the calculation of the separate property component in community property, or a community property component in separate property. The case itself had to do with a gentleman who was divorced twice, and in the first divorce he kept the house, and then he remarried, and over the years he and wife number 2 continued to pay down the mortgage, did the landscaping, improved the kitchen, all that sort of stuff. When that marriage broke down, the question was, what interest, if any, does wife 2 have in this house, which remained in the name of the husband? And there's a very long and intimidating looking bunch of algebra in the opinion as to how to figure out the interest of a spouse in separately titled property. So we developed a calculator for that. That was Malmquistizer was MLaw 3. MLaw 4 will be coming out fairly shortly. The Child Support Commission has about to issue regulations which will replace our child support statutes. The new calculations are substantially more complicated than our existing child support provisions. So we are going to have online, hopefully on the day the regulations go into effect, a calculator which will allow anybody to simply answer a series of questions and very quickly figure out what child support is allocable to who, no matter what kind of division we've got of kids in one household, kids in the other household, income levels of the parties, at poverty level, not at poverty level, and even if they're split custody. And those are the calculations that got a lot more complicated under both the new regulations that are about to come out and under some cases that came out in the last few years. So the idea of the MLaw suite is to make sure that the information is available to anybody that needs it. It's available in the self-help centers, it's available in the law libraries, it's going to be running in the courtroom, so even proper person litigants who have complex child custody and support matters should be able in very short order to get an appropriate child support order. And they also can, of course, do the calculations for arrears, interest, and penalties, although the penalties should be going away in the new regulations, and that also will be taken into account in our calculator programs, so that old arrears will still have penalties and new arrears won't. Like I said, the calculations can get pretty complicated if you try to do them by hand.
Wow, I did not know that there was that much. That's just a lot. Like, first off, the fact that it's been around for that long is surprising and impressive. And then, I mean, the whole key where it's the access to law perspective, the level the playing field. That idea is new, and I know that they have some other software out there, for example, Westlaw, but my understanding is it's not very accessible or affordable. One of the two to the non-attorney, to the proper person litigant. So we might have to talk about that a whole lot more. Maybe when the next version comes out. I know that there are a lot of people that contact us with questions connected to the child support guidelines. But for today, thank you so much for your time. It's much appreciated.
You're welcome, and I wish you the best. Take care.